and welcome to week 7 of our 5 tips series. This week we're talking about non-disclosure agreements, or NDAs as they're usually called. No matter what field you are in, this may be relevant at some point in time. Confidentiality is an important facet of our daily professions and business transactions, and it is integral for forging new business opportunities between parties. This is part 7 of our 5 tip series, where I'll be sharing 5 tips each week that are beneficial for businesses, small to medium-sized entities, artists, innovators, designers, photographers, filmmakers, and essentially anyone who has an idea and wants to create and protect it. I'll be sharing tips on how to level up and take your business or craft to the next stage. And most importantly, protect what you create. These tips were formulated from questions I'm commonly asked and also from real-life client issues. If you missed the previous part, be sure to check it out on my YouTube channel, Teresa Kalu. I've seen an increase in the use of non-disclosure agreements recently, which is great, but often persons come with very generic agreements which may not hold much weight or protect what it is intended to protect. While NDAs can be pretty boilerplate and standard, there are still some things you need to pay attention to ensure that it will be effective. First off, an NDA is just usually a preliminary document between parties to enable them to speak about certain things and share certain information, and it either bounds one party or bounds both parties to confidentiality. However, while this is definitely always a recommended step, it does not stop persons from actually disclosing confidential information. What it does is that it gives you the opportunity to bring some sort of proceedings against the other person for illicitly using your confidential information, or for improperly storing the information, or for revealing that information that was unauthorized for a third party. Some persons get a false sense of security with an NDA and sometimes reveal information that they either 1. cannot prove was their confidential information, or 2. was not properly covered in the NDA. So, here are my 5 tips to note before you disclose. Tip number 1. Describe the purpose. When you meet with someone to discuss anything confidential, there is some reason or purpose you are disclosing sensitive information to them. It is important to state what that reason is so that the person is limited to what they can do with the information provided. For example, if you have decided to create a new invention, let's say you created a Bluetooth webcam. You've named this Bluetooth webcam BlueCam 1, and it is a great invention as it has a higher resolution than all the other webcams existing in the market. Plus, it's Bluetooth, so no extra cords, and it doesn't use any extra ports. Now that I think about it, I should have probably made everyone sign an NDA before listening to this video, because I think I'm onto something here. But anyways, if you have this invention and you're meeting with a person or business that can manufacture the invention for you, you should state in the NDA that the purpose is to license the right to manufacture BlueCam 1. This immediately, 1. identifies what product you are meeting on, and 2. what the receiving party is potentially allowed to do with the information provided. So, for example, if this party begins to manufacture and distribute your product without your permission, you have in writing that the meeting was solely connected with the manufacturing of the product as opposed to distribution. It also specifies that it is a license or permission to do something and not an assignment or passing over of any rights to the invention. So immediately, you limit the number of things the person receiving the confidential information can do with that information. Tip number 2, be specific. You need to be specific about what information or documents are considered to be confidential and identify as much as possible what exactly is being disclosed. But you need to do this without revealing too much. Everything is not confidential and will not be deemed as confidential. It is therefore important to identify before the meeting what your confidential information is. This usually includes any information not known by the public, information on customers or prices, information on how you do certain things, also known as your know-how, and most importantly, anything that is a trade secret. When you have identified what is confidential, you then need to determine what you need to continue to keep secret and what you can disclose to the other party without giving too much away. These meetings entail a delicate balance between giving enough information to form the relationship with the other party, but also holding back enough information so that the recipient of the information leaves there without knowing exactly how to replicate your idea or what you have created. When drafting the NDA, therefore, you have to carefully draft what is being disclosed so as to give protection to it. Using the same example of Bluecam 1, you have created two things which have value: the high resolution and the fact that the webcam uses Bluetooth technology. Because you are not selling the product to the persons in this scenario, they require even less information. So they may not necessarily need to know the Bluetooth component in the initial meeting. Revealing the high resolution of the webcam, however, may not cause issues as they may still not know how to actually do it. Therefore, you can state that the NDA is to protect the disclosure of your Bluecam 1 technology, which is a webcam with whatever the specific resolution. Here, you have been specific to identify that there is some trade secret or possible patentable technology existing in your webcam that requires protection and confidentiality. And you have not revealed what exactly that secret is. It would therefore be specific enough to enable protection without putting the disclosure at too much risk. Tip number 3. Protect your work. Even though your NDA offers some level of protection when disclosing, it is advised to protect your work as much as possible before entering into the NDA. You can conduct a small IP audit, and if you're not familiar with what that is, I'll be giving tips on this next week. Essentially, you should identify any intellectual property subsisting in your product and try to protect it before disclosing. So, for our Bluecam 1, if we're using Bluecam 1 as our brand, we have to make sure and protect it as a trademark. You also need to decide how to protect it. Is it better to protect it by trade secret? Is it that persons could figure out how to do it? What about it persons can't figure out? Make sure you protect that secret. Or if you want to file for a patent, you should probably file for the patent before entering into the NDA with the manufacturer. Sometimes it may not be feasible to file for protection before, but it is important to at least know what intellectual property, if any, is subsisting so that you can be cautious in the disclosing process. Tip number 4. Specify the term. One thing you need to be mindful of is the duration that the information needs to be kept confidential. Most NDAs specify anywhere between 1 to 5 years, but it has to be specific and reasonable to what you're disclosing. So if you're discussing something that is going to become public in a couple months, the NDA can probably be in effect for that period. However, if you're disclosing something that has to remain confidential beyond the actual business relationship, you have to ensure you specify that the obligation survives whatever other agreement you may have. In our BlueCam 1, if you are protecting this by trade secret, because you are confident it cannot be easily figured out or reverse engineered, you would need an NDA with the potential manufacturer to last as long as the secret is kept. Well, secret. This is particularly so where you have no choice but to reveal to the manufacturer how it is done. Tip number 5. Identify a dispute resolution plan. My last tip today is to identify a dispute resolution plan. While we always hope that there will be no need to use this part of the agreement, it's good to think ahead of how you would like to deal with any breaches of the NDA, should they arise. Litigation can be expensive, lengthy, and may require you to disclose information publicly. It is therefore important to look at the nature of what you're disclosing and decide whether you would want to utilize the court system or whether you would want to include an alternative dispute resolution procedure. Alternative resolutions include options such as mediation and arbitration. These can sometimes be quicker and cheaper options. However, depending on what is being disclosed, that will determine what is the best route. Some types of illicit disclosure may require injunctive relief, whereas some can be dealt with through mediation or arbitration. What is important is to formulate a plan from the beginning as to how you would like to deal with these disputes and resolve them. And you need to specify this in your NDA. That's my 5 tips for this week. I hope it has shed some light on some important things to include in your NDA and some preventative measures you can take. Always remember that NDAs are not always a one-size-fits-all, so you need to be careful when relying on one and know how to use it to your advantage. As a rule of thumb, when you come out of a meeting after disclosing confidential information, you should leave the recipient still not knowing everything. While these legal measures are put in place to help protect you, they're not foolproof, and so you still need to be cautious. As I said previously, next week I'll be discussing intellectual property audits, which can be very beneficial to conduct prior to entering into these NDAs. Until next time.